Ready, start. The learned magistrate grossly erred while directing the appellant to remain personally present in the court. Full stop. While passing the order dated 15th September 2022, the learned JMFC took into account the fact that the passport of the appellant was impounded by the concerned authorities on 3rd October, 2018, and when the appellant lay challenge to this act of impounding before the High Court of Calcutta by filing a writ petition being WPA number 4743 of 2020, the same was also dismissed by the High Court by judgment and order dated 15th January, 2021, while affirming the revocation and barring the appellant herein from filing any appeal under Section 11 of the Passport Act, 1967, full stop. It is apparent that the appellant's inability to travel to India and appear in miscellaneous case number 440 of 2022, filed by the respondent under Section 26 of the DV Act, stemmed from the impoundment of his passport, a circumstance beyond his control, full stop. Consequently, the order of the learned JMFC directing the initiation of extradition proceedings against the appellant as a consequence of his non-appearance, despite being aware of the fact of impounding of the passport of the appellant, is untenable and unsustainable in the eyes of the law. Full stop. Otherwise, also, as noted above, there is no requirement for the personal presence of any party in the proceedings under the DV Act, because they are quasi-criminal in nature and do not entail any penal consequences except when there is a breach of a protection order, which is the only offence provided under Section 31 of the DV Act. Full stop. The appellant challenged the order dated 15th September, 2022, passed by the learned JMFC by filing criminal revision being CRR number 135 of 2023 before the High Court of Calcutta. Full stop. However, the High Court void a non-speaking order dated 25th January, 2023, dismissed the revision petition, stating that no grounds for interference were made out. Full stop. This court is of the considered opinion that the High Court could have examined the record of the case, particularly the reasons for the appellant's failure to appear due to circumstances beyond his control, and hence, a reasoned decision addressing the merits of the matter was expected in these circumstances. Full stop. In the wake of the above discussion, the order dated 15th September, 2022, passed by the trial court, and the order dated 25th January, 2023, passed by the High Court of Calcutta, are liable to be quashed and set aside. Full stop. The next question that arises for our consideration is whether there is an irretrievable breakdown of the marriage of the appellant and the respondent, requiring this court to exercise its extraordinary jurisdiction under Article 142 of the Constitution of India to do complete justice. Full stop. The issue regarding the invocation of the extraordinary powers of this court under Article 142 within bracket 1 of the Constitution of India in cases of marital disputes is no longer res integra and has been settled by the Constitution bench of this court in Silpa Shailesh versus Varun Srinivasan. Full stop. The court held that in the exercise of the power under Article 142 within bracket 1 of the Constitution of India, this court has discretion to dissolve the marriage on the ground of its irretrievable breakdown. Full stop. This question is also answered in within bracket 6 bracket close affirmative, inter alia, holding that this court, in the exercise of power under Article 142 within bracket 1 of the Constitution of India, has the discretion to dissolve the marriage on the ground of its irretrievable breakdown. Full stop. This discretionary power is to be exercised to do single inverted comma complete justice single inverted comma close to the parties comma wherein this court is satisfied that the facts established so that the marriage has completely failed comma and there is no possibility that the parties will cohabit together comma and continuation of the formal legal relationship is unjustified full stop. The court comma as a court of equity comma is required to also balance the circumstances and the background in which the party opposing the dissolution is placed full stop. The constitution bench further laid down the factors to be considered for such determination comma which were also reiterated in the case of Kiran Jyot Mani versus Anish Pramod Patel full stop. This court comma in both the judgments comma opined that the factors to be examined inter alia include the period of cohabitation between the parties after marriage semicolon the last cohabitation among the parties semicolon the period of separation semicolon the nature and the gravity of allegations made by the parties against each other and their family members semicolon the orders passed in the legal proceedings from time to time comma cumulative impact on the personal relationship semicolon whether comma and how many attempts were made to settle the disputes by intervention of the court or through mediation comma and such other similar factors full stop.